Unconsciousability. The defense of unconsciousability is related to the cause of action for rescission. The gist is that if a party has become the unwitting victim of a contract procured by fraud, overreaching, or otherwise by unjust means, the court should not enforce that contract, even though the plaintiff is a victim of his own foolishness and lack of caution. Now that leads me back to the maximum. The plaintiff cannot benefit from his own wrong, okay? And when we look at that, the one who bears the benefit also bears the burden, all right? That's the maximum of law as well that goes with that. To prevail with this defense, the defendant must show the court that the contract in itself, i.e., aside from related factors, was outrageously unfair, and that the proceedings leading up to the parties entering into the contract were also outrageously unfair. The first requirement is called substantive unconsciousability, wherein the terms of the contract itself are deemed to be unreasonably favorable to the plaintiff seeking to sue on the contract. The second requirement is called procedural unconsciousability, wherein there was lack of any meaningful choice on the part of the defendant when he entered the contract. Perhaps he was too feeble, or perhaps he lacked all understanding of technical aspects of the promise made to him. Either way, there was no meeting of the minds essential to the formation of an enforceable contract, and therein lies the gist of this defense. It has been said at the common law that an unconscionable contract is one that no man in his right mind and not under delusion would make on the one hand, and no fair and honest man would attempt to enforce on the other. Some authorities refer to the receptive bargaining powers of the parties and the ability of the one to understand the terms and the conditions communicated by the other. Synonymous for unconscionable include shocking the conscience, monstrously harsh, grossly unfair, etc. Unconscionability is an effective affirmative defense that must be pled at the outset of the case, or it is waived. Undue influence. Undue influence is a cause of action to avoid the legal effect of a document, ergo, a will, deed, trust, or similar conveyance of rights of property procured from a person of weakened mental ability by a person who occupied a position of trust with the person of diminished ability. The court's favorable judgment prevents the latter from gaining unjust advantage from his unduly influencing the former. The most common case, of course, involves the greedy sibling who importunes an elder family member to change the will, cutting the other brothers and sisters out. Now, I'll tell you a little story about a guy who was extraordinarily wealthy. Dodge City, Kansas, back in the day, was a hustling, bustling cattle town, all right? And this man happened to be a big part of Dodge City, Kansas. He owned quite a bit in Dodge City, Kansas, from hotels to feedlots, sale yards, you name it. And when he passed away, he had a son who went to one of his wealthy friends' house and stole a priceless painting that can't be replicated. It was an original Picasso. He stole it. It was like $1.5 million painting. They later recovered it. But the moral of the story here is he didn't raise his son to be a thief. In fact, his son had everything he could ever fucking want. But unfortunately, he had sticky fucking fingers. He always wanted what he couldn't fucking have. And because of that, when the man created his will, he wrote him out of the will. Now, his lawyer had explained to him, hey, by writing him out of his will, he will have grounds to come back and argue that you forgot about him. And he says, what do you mean? He says, well, if you give something to everybody else, if you divide your wealth up between all the rest of your siblings and offspring, but you leave him out, he will have grounds of a cause of action to come back to challenge the will, stating that he was simply forgotten. So what this man did in his brilliant intelligence is he left his son with a fucking dollar. $1. And the only reason he left him $1 fucking dollar is so he couldn't come back into the court and challenge the will, saying, hey, my father clearly forgot about me. It was a big fuck you for being an asshole and being a thief. And that's something, a number of men in my life have always told me, Derek, if you ever become a thief or a fucking liar, we'll disown you. We don't want to be associated with that shit. And it meant a lot to me. when we think about the old bulls, and so much is being lost in the generations that are dying off, one of the key fundamental principles that they always, always, always pressed upon me was, and with some of the harshest lessons too, from just flat out ignoring me, not talking to me for months on end, which really destroyed a young fella, but it taught me a great lesson. And that is, if you're a thief or a fucking liar, people don't want to be with you. They don't want to be around you. Okay. If those are the kind of traits and characteristics that you think have value or that you carry with you, knowing that it's wrong and you still do it, you're going to be a lonely motherfucker the rest of your life. Okay. So the moral of the story is, keep your sticky fucking fingers to yourself. Don't touch what don't belong to you. Don't touch other people. Don't fucking take what don't belong to you. And life will be pretty fucking easy going for you. All right. So that was a little lesson on wills and estates and what this man did to ensure that his son was only left $1 out of $100 million fucking estate. $1. And it was a nice fuck you for being an asshole. Elements. 1. Existence of a confidential relationship between beneficiary and grantor. 2. Beneficiary activity procured the instrument, will, trust, deed, etc. 3. Grantor suffered some condition lessening her ability to resist the influence. Element 3 may not be required by all courts. However, it is an essential element in some jurisdictions, since it should not be argued that the grantor, in perfect physical and mental health, having average intelligence and understanding of the nature of his estate and the natural objects of his bounty, loved ones, family, etc., could reasonably be said to be unduly influenced to dispose of property in a manner contrary to his free will, unless he was subjected to actual duress, i.e. coercion, a different cause of action. In an actual case in Miami, an extremely elderly gentleman having only distant relatives and a various stockbroker died, leaving $12 million to the stockbroker, with whom he enjoyed a confidential relationship and who, being also an attorney, drafted the will by which the old gentleman signed away his millions. These facts clearly gave rise to a cause of action for undue influence. In another's case, it is a disgruntled sibling complaining that his sister received the bulk of their father's estate and brought an action for undue influence. The sister, however, had nothing to do with the procuring of the will, nor did the sister live in the same state with the decedent or have any confidential relationship with the decedent greater than the relationship her brother also enjoyed. So the cause of action failed because requisite elements were not present. Comments. If the beneficiary enjoys a requisite confidential relationship and also procured the will or other document, ergo, taking the elderly person to the beneficiary's lawyer to have the will drafted, a presumption of undue influence arises in most jurisdictions. Once a presumption arises, the burden shifts to the procuring beneficiary to prove the absence of some or all elements of undue influence. Favorable judgment nullifies those provisions of the document procured by the undue influence, restoring the situation to what it was before the document was executed. Unjust enrichment. The gist of unjust enrichment is similar to the cause of action for quantum merit. That's MERUIT. Don't know if I'm pronouncing that correctly, but quantum merit. That arises when one person confers a benefit on another under circumstances that would cause a reasonable person to believe he would be compensated by the other. The courts reason that one person should not be unjustly enriched at the expense of another. So, even where there is no contract between them to spell out in detail their relative expectations, this cause of action, or quantum merit, will lie to prevent the one from being unjustly enriched at the expense of the other. Element. The essential elements of the fact that must be pled and proved are: 1. The plaintiff conferred a benefit on the defendant. 2. The defendant either requested the benefit or knowingly and voluntarily accepted it. And 3. Circumstances surrounding the transaction were such that it would be unjust for the defendant to retain the benefit without compensating plaintiffs reasonably. An example that might give rise to this cause of action is seen where an inert house painter Oh, excuse me. I think that's supposed to say interior. Interior house painter asks a homeowner if he can paint the homeowner's house. The homeowner answers, of course, seeing an opportunity to get a free coat of paint and thinking that because he has not agreed on a price, that is not bound to pay for the job. In fact, the court will imply a contract under the circumstances, awarding the house painter the fair market value of his services because it would be unjust to do otherwise. Now, that's not necessarily true. All right. If I offer to wash your car, mow your yard, and I do it, and later on I want payment for it, I'm going to tell you right now, you have a solid affirmative defense. That's considered a gift. I gifted you my labor, my life source energy. You know, it was something that I offered, and we didn't negotiate the terms and the price necessarily. Now, on the adverse side of that, when you're being compelled to go into a court, guess what, baby? You can get fucking paid. You can get paid. Everybody else in that courtroom's getting paid. Judge getting paid, clerk's getting paid, jury's getting paid, the prosecutor's getting paid, all the court staff's getting paid. You are the only one in the game that's getting the fucking shaft. So make sure to submit them a proper bill due and owing, a true bill due and owing with an itemized list of how much time you spent, what you did, where you showed up, when you arrived, what you're billing per hour, because they didn't discuss what you were going to be paid. You were entitled to being paid, okay? Because they're running a simulated legal process as an artificial Ponzi scheme, or a artifice and a Ponzi scheme in order to extort you your life source energy, and you should be handsomely compensated for that, all right? That's the only way these people stop, is when you start taking big chunks out of their fucking wallet. Okay, defense. Express contract. This cause of action fails if the defendant can show that an express contract exists, whether verbal or in writing. The idea that the term of express contract are more likely to convey the actual understanding of the parties, and they should be held to the terms of that express contract. Burden. The plaintiff seeking to enforce an implied contract is required to meet the greater burden than one who uses better business sense by requiring an express contract before undertaking to render services or deliver valuable goods to another. Payment accepted. Once plaintiff accepts payment for his services or delivered goods, he cannot then sue for unjust enrichment, and a motion to dismiss will prevail. Waiver. Waiver is an affirmative defense that arises when plaintiff has waived the right or privilege upon which he sues. The right or privilege waived must, of course, first exist, or there is nothing to be waived. So this is one of the elements. A second element is that the waiver must be knowing, i.e. intelligently, knowing, willingly, and intelligently done by the plaintiff. The plaintiff cannot have waived a right or a privilege without knowing or having constructive knowledge of the fact. Finally, the plaintiff must have waived with actual intention to relinquish the right or privilege. Elements. In order to successfully assert this defense, the defendant must allege in his initial response to the complaint that 1. Plaintiff possessed a right or a privilege upon which he has brought his lawsuit. 2. Plaintiff waived the right or privilege. 3. Plaintiff knew or should have known he waived the right or privilege. And 4. Plaintiff intended by his waiver to relinquish the right or privilege. For the court to imply the waiver from the plaintiff's conduct, facts relied upon to demonstrate that the waiver occurred must be clear and convincing. Mere inferences are not enough, however probable they might be. In the absence of a direct fact demonstrating waiver, the defendant must meet a heavy burden for the court to imply a waiver. In some jurisdictions, particular waivers cannot be established unless evidenced by some express writing that demonstrates knowledge of the act and its consequences. See local statutes and case law for details in your jurisdiction. And again, I hate this fucking thing, case law. I fucking despise it on a cellular level. It's a misdirect. It's a menagerie of words that should never be put together. There is no such thing as case law. It is case fucking precedent, okay? Case law doesn't exist because the judiciary has not been granted the authority to make fucking law, all right? Conclusion. The meat and the potatoes of every lawsuit are 1, the laws, and 2, the facts. The right to sue on laws and facts, however, depends on the plaintiffs having at least one valid cause of action the courts in his jurisdiction recognize. Although there are a few causes of action not listed in this tutorial. We have covered those that include most of the cases you'll encounter. Others arise from particular statutory enactments and deal with particular facts, circumstances that affect only a rare few. Of course, the right to sue can be challenged by valid defense, and we have listed a few of the more common affirmative defenses and the elements that must be pled to defeat the plaintiff's intentions. Knowing the elements of the cause of action and common defense is half of the battle of winning a lawsuit. The rest is common sense, effective discovery, and above all, being the person who should win. The trust of keeping American justice alive is in your hands. Teach the process to your children. Act justly towards others. Do good works. Live long and prosper. That concludes our second book. This book, again, all these books are about 70 to 80 pages long. This book was called Cause of Action and Civil Defense. I don't know if you can find it on the internet anymore. This one was harvested from the internet a long time ago by James Bethel. And so we thank James Bethel for his commitment to freedom and to helping educate his fellow brothers and sisters, and for taking me under his wing and being my mentor. I really appreciate you, James, and thank you so much for all that you have done for me and what you're doing for the American people now through me. I really appreciate it. Always remember that we should do things in good faith, good conscience, with good reason, with clean hands, all right? And we should always strive to do the works of the Heavenly Father to the best of our ability. Thank you very much for joining me, and when we come back, we'll be doing another book. Maybe we'll go into defenses. I got evidence, I got forms, I got hiring, I got how to win, language, maxims, motions, natural. We've already covered objections. We've got summary, and then the trial, of course. And this is a series of books that was put together by a lawyer. Some of the information I agree with, some of it I don't agree with, but again, it's